Two articles in the Constitution has been in debate for the past 1 week. The debate for one article is with respect to the lack of clarity, while the debate on the second article is with respect to the lack of enforceability. Today, we will be discussing about these two articles and the issues arising out of it. Welcome to another one episode of the weekly current affairs video from Amrita IAS Academy. I am Manish Nambiyar, the Faculty for Indian Polity and Governance. The first news which we have to discuss today is with respect to the opinion given by one of the judges of the Supreme Court of India. The Supreme Court news is Justice 𝐏𝐻𝐸𝐺𝐸. He commented about the lack of transparency which is ongoing within the Collegium System of the Supreme Court of India. So now we need to know, what does this Collegium means? What are their powers? What are their mandates? How the Constitution is describing or prescribing the procedures for the appointment of judges to the Supreme Court and the High Court. So now first we will look into this particular matter with respect to the appointment of judges to the Higher Judiciary in India. So in the introduction I have told you with respect to the lack of clarity in the articles of the Constitution. Now this particular case with respect to the appointment of the judges to the Higher Judiciary is stemming out of a concern with respect to this lack of clarity. Now, if you look at the Constitution of India, Articles 124 and 217, the first one is dealing with the appointment of judges to the Supreme Court of India, and the second one, that is 217, is dealing with the appointment of judges to the high courts in different states of India. So both these articles 124 and 217 says that the judges to the Supreme Court and the high courts respectively shall be appointed by the President of India. There is no confusion to that particular matter. Now one more statement is present in both these articles, and that statement says that President shall make these appointments after consulting the Chief Justice of India and any other judges as he may consider. So the appointment procedure for the Supreme Court under Article 124 and to the High Courts under Article 217. Both of them prescribes a manner in which the appointment shall be done by the head of the state, that is the President of India, after a wide range of consultations where the President is mandated to consult the Chief Justice of India and any other number of judges as the President of India may consider. So that is Article 124 and Article 217 for you. Now the things were ongoing in India, and due to different issues, there were some allegations against the appointment of judges to both the Supreme Court as well as the High Courts. Then a case was raised in the Supreme Court of India, and that is known as the first judges case, which is actually S.P. Gupta case. So in this particular case, the Supreme Court of India said that Article 124 and Article 217 only says consultation. The President has to consult. Whether the President has to obey or the President is supposed to obey the guidance given by the CJI, that particular part the Constitution is silent. So the Supreme Court of India in the first judge's case said that in case of any difference of opinion between the President and the CJI, the opinion given by the President shall prevail over the Chief Justice of India. That was the judgment given by the Supreme Court of India in the S.P. Gupta case, which means the consultation is not a concurrence, that is just a consultative procedure. Now, in the next case in 1993, in the Supreme Court Advocates on Records case, in that particular case, which is also known as the second judge's case, in that particular case, the Supreme Court of India overturned their judgment in the S.P. Gupta case, and they have said that consultation, the term consultation as mentioned under Article 124 and Article 217 means concurrence. That is, the opinion given by the CJI is binding on the President of India. So that was the first judgment given in the second judge's case. That is, the President has to obey the judgment given by or the guidance given by the CJI. But one more condition was placed. When the CJI is giving this opinion to the President, the CJI shall consult a collegium, and this particular collegium shall comprise of two senior most judges of the Supreme Court and the CJI. So, revisiting Article 124 and 217, Article 124 and 217 is prescribing for a consultative mechanism between President and CJI. Now, the second judge's case is saying that when the CJI is consulting the President, the opinion of CJI shall be the opinion of the Collegium, where the Collegium shall comprise of the two senior most judges of Supreme Court and the Chief Justice of India. That was a judgment given by the Supreme Court of India. So, the concept of an extra constitutional mechanism, that is a collegium system, was introduced in the second judge's case, or actual name is Supreme Court Advocates on Record case. So, that was the judgment. Then later, in the third judge's case, see, third judge's case was actually a presidential reference case. Okay, so the President of India, Article 143 of the Constitution, referred a matter to the Supreme Court of India to revisit the second judge's case. And in this particular case, the Supreme Court of India said that as part of the consultation under Article 143, Supreme Court said that Article 124 and Article 217 as interpreted in the second judge's case will prevail, or in other words, consultation is concurrence. There will be no changes to that. Okay, so the opinion given by the Chief Justice of India to the President of India is binding on the President. But a new change has been introduced. The Collegium has been expanded from a system of 2+1 towards the system of 4+1, where the CJI shall consult 4 senior most judges of the Supreme Court when it comes to the appointment of the judges of Supreme Court. So, this was a system of the appointment of judges to the Supreme Court and High Court, which was created after the 3 judges case in India. That is, President shall make the appointment, there is no confusion. But when the President is making the appointment, the President should consult the CJI, who will consult the Collegium, which shall comprise of the 4 senior most judges of Supreme Court when it comes to the appointment of the judges of the Supreme Court. Okay, so that was the opinion given there. Then later, in 2014, through the 99th Constitutional Amendment Act, National Judicial Appointments Commission was created by the Parliament of India through a constitutional amendment as under Article 368. So, this particular commission, 𝐿𝐴𝐺, was intended to replace the Collegium. So, Collegium, which was an extra constitutional mechanism, which was supposed to give advice to the President of India, was replaced with the National Judicial Appointments Commission. And this particular National Judicial Appointments Commission was created as a constitutional body under Article 124A. This particular 𝐿𝐴𝐺 shall comprise of Chief Justice of India and 2 senior most judges of the Supreme Court. So, 3 judges from the side of the judiciary. Now, the Union Law Minister and 2 members as recommended by the executive. So, 3 members from the side of the executive, 3 members from the side of the judiciary, and CJI will be the chairperson of the particular committee. So, such a system was created through the 99th Constitutional Amendment Act. But what happened? Then later, in the 4th judge's case, in that particular case, the Supreme Court of India said that National Judicial Appointments Commission is violating the principles of independence of judiciary. How? By involving the executive in the matters of deciding the appointments to the judges. So, in that particular manner, the National Judicial Appointments Commission, as created by the 99th Constitutional Amendment Act of the Parliament of India, was declared null, void and unconstitutional since it was violating the basic structure of the Constitution, because it was already declared by the Supreme Court that independence of judiciary is part of the basic structure. So, 𝐿𝐴𝐺 was struck down. Now, what is the issue? After this particular 𝐿𝐴𝐺 judgment or the 4th judge's case, the Supreme Court themselves acknowledged that the proceedings of the Collegium is not that much transparent. There is some opacity which is ongoing within the Collegium system. Even though they oppose the 𝐿𝐴𝐺, they have admitted that the Collegium is not functioning in a manner which is desirable to the ideals of transparency. Now, after the 4th judge's case, the Supreme Court themselves admitted that the collegium system is not working according to the ideals of transparency. So, what the Supreme Court proposed was that from now onwards, the collegium will publish its discussions and its particular minutes of the meetings which are ongoing, and also the collegium will publish the basis for the recommendation of the judges, the basis for the transfer of the judges, and all those details. And initially from 2015 till 2017, the things were going smoothly. The Supreme Court of India, the collegium used to publish their discussions, their debates, and all these things. But then later the issue restarted, the issue resurfaced again after the collegium started pausing the publishing of these particular documents. Sometimes it will be published, sometimes it will not be. And it was this particular matter which triggered the judge of a Supreme Court himself to point out this matter with respect to the lack of transparency which is happening within the collegium. So now you know how the collegium system was evolved, what the article is saying about the constitutional appointment, and how the article 124 and 217 is silent in this matter. Now we need to also look into a particular single matter, that is with respect to the validity of this particular issue and the transparency of the Supreme Court of India and the collegium. As we speak right now, the system of transparency is not directly applicable to the Supreme Court. We know that according to the Right to Information Act of 2005, the concept of transparency has been extended to all public offices, but the judiciary was not part of that particular system. Now, through the Supreme Court of India versus Subhash Chandra Agarwal case of 2020, the Supreme Court of India clarified that the office of CJI will come under the ambit of RTI. So, the concept of RTI was extended to the office of CJI, but even then, collegium was not included. So, still there is no legal mechanism to publish the documents, or maybe to make them accountable to publish the documents. Now, then later, with respect to the 214th report of the Law Commission of India, the Law Commission said that collegium system is ensuring a system of consultation. Whether it is working or not, that is one another question, but at least if you consider the judgment of the Supreme Court in second and third judges cases, there is a provision for consultation where an appointment to the Supreme Court and High Court will be happening only after wide range of consultations. So, in that perspective, collegium is good. That was the opinion of the Law Commission of India. But at the same time, this system of collegium should be made more transparent. It should be widening their consultation processes. So, that was the judgment given by the, not the judgment, that was the opinion given by the Law Commission. That is, need more consultation, need more transparency. So, that was the opinion of the Law Commission of India. Now, many scholars and many people are questioning why the government should be involved in this process, why NJAC is necessary. There we have to understand one point. Both Article 124 and Article 217 says that appointment shall be done by the President after consulting the CJI and any other judges. So, here we need to understand two things. One, the President was given a responsibility to consult. By the creation of the collegium system, now the consultation is being taken away from the President, and now the consultation is vested with the collegium. So, the collegium system is bypassing the power or the authority given to the President under Article 124 and 217, where the President was supposed to consult other judges. Now, that has been taken up by the collegium, which is against or which is not mentioned under the Constitution of India. That is one thing. Now, President of India is bound by the aid and advice of the Council of Ministers, and this particular Council of Ministers are responsible to the Parliament of India. So, now what happens? Initially, the framework of Article 124 and Article 217 created a system where the parliamentary system of governance, where the Parliament, which is the representative of the people of India, can make the Council of Ministers accountable even in the matters of appointment of the judges. Now what happens? When any allegations come against the judges of Supreme Court or High Court, or whenever there is some issues with respect to accountability or with respect to the integrity of the judges, Parliament has least powers of enforceability. Why? Because the appointment of judges is now dominated by the Collegium System, where the President is bound by the aid and advice of Collegium, which is not answerable to the Parliament of India. So that's why that particular debate on whether the NJAC is necessary or whether the Collegium is sufficient or whether the Collegium is extra constitutional is still relevant. Now, to rectify these issues, we have some global practices which are ahead of us, starting with the system of appointment of the judges in the United States of America. Now, when it comes to the American system, the judges to the state courts, the high courts, just like the high courts of our India, the courts in states in the USA, the judges are appointed after an election. So, judges has to face an election and then only they will be appointed. Now, to the Supreme Court of USA, judges are appointed. So, Supreme Court of USA, judges are appointed by the President. President of USA appoints them. But now there is a condition. Once when the recommendation is made by the President of USA, the Senate, which is the House of the States in USA, has to approve that through a passing of resolution. So, now there is an involvement of the representative of the people. So, that is one model which India can have for the future. Now, the systems of appointment in Australia, New Zealand and Canada is dominated by the executive, where the judiciary has zero role, where the rest of the systems also do not have zero role, just the executive is managing it. Now, when it comes to United Kingdom and Kenya, in both these nations, they have a Judicial Appointments Commission, which is comprising of members whose sole responsibility is to make recommendations, is to track the performance of the judges. Now, when it comes to the nation France, their system is that judges to the high levels of courts, the higher courts, are appointed from the judicial services. That is, people will be participating in a competitive exam to enter the judicial service at the lower levels. From there, they will get promoted and through that process they will be reaching the higher courts, just like the civil services in India. So, these are the practices which can be followed by India to rectify this issue. So, that was the discussion with respect to Article 124, Article 217 and the constitutional silence which paved the door to this particular issue. Now, coming to the second topic in discussion, which is highly relevant since years, since decades, this particular topic is in news. Now, considering the relevance of this news in the recent terms, Taslima Nasrin, one of the writers from Bangladesh, she had voiced the necessity of uniform civil code, which is mandatory for every nation. So, her opinion for uniform civil code was connected to the rights of women. So, she had stated the cause of rights of women and equality, gender equality, and for that purpose she had stated that uniform civil code is necessary. So, now let us look at the aspects of the constitution, what the Constitution of India says and what the different commissions and Supreme Court had said with respect to this particular matter. If you look at the Constitution of India, Part 4 of the Constitution, that is the directive principles of the state policy, and specifically the Article 44 of the Constitution, says that the state shall make efforts to create a uniform civil code for the nation India. So, what does that mean? The directive principle is giving a direction to the state, that is either the central government or the state governments, to create a uniform civil code for the nation. But you know that directive principles are non-enforceable and they are non-justiciable, which means unlike Part 3 and fundamental rights, it is not mandatory upon the state. Now, if you look at the situation in India, as of now, at the national level, we do not have a uniform civil code. But at state level, if you look at different states in India, Goa is a state in which they had a uniform civil code since their formation. See, they are following a law which has been followed since the Portuguese, a civil law which has been followed since then. So, they are still continuing with that process. Now if you look at the states in India which has adopted a uniform civil code after the constitution, that is a new modernly created uniform civil code, Uttarakhand was the first state, that is in 2024 they created a uniform civil code for them. Then Gujarat, Assam, Madhya Pradesh, these were the states who adopted a uniform civil code recently in 2026. So now we need to know why this particular thing is relevant. So a civil code or a uniform civil code makes sure that the civilian laws in the nation are being administered not on the basis of the socio-cultural backgrounds but in the basis of a neutral liberal law which all of us has to follow. So that is a basic ideal behind it. But why we do not have a national level uniform civil code even today? The reason is simple. The cultural diversity of the nation and the apprehensions of the minorities in India should be addressed first before creating a uniform civil code. That is the reason why the state is in a dilemma on whether to create a uniform civil code and whether not to go with a uniform civil code. Now let us look into the opinion of the Supreme Court and opinion of the commissions with respect to this particular matter. Supreme Court of India had said that a uniform civil code is desirable, but we cannot enforce it since it comes under the domain of the legislature. So that was the opinion of the Supreme Court. They have said that it is desirable, but we cannot force the legislature to implement it. Now when we look at the recommendation given by the law commissions in India, that is very important. The 21st Law Commission of India said that it is neither necessary, it is nor desirable. That is, the Law Commission said that creation of a new uniform civil code is not going to make much changes to the system of civilian laws in India, or it is not desirable to the nation. But recently the 22nd Law Commission of India said that we need to have some new efforts to garner different opinions, which means the Law Commission is favoring the creation of a uniform civil code, but before the creation they need to get more opinion from different people. So that is the situation. So Article 44 of the Constitution, even though it is giving us a clarity, since it is a DPSP and since it is non-enforceable and non-justiciable, even today we as a nation as a whole, we do not have a uniform civil code. Now let us see how the union government will proceed with the matter and the union parliament will implement it. So we have concluded the two articles. One was the ambiguity in the constitution and second one was the non-enforceability as proposed in the DPSP. Thank you.
Amrita IAS Academy.